All right, let's get started. This is the August meeting of the DFW Note Closers Group. I'm Kimberly Banks Fawcett. I've been running this group for almost 3 years now. And tonight we are super excited to have a guest speaker. Daniel Singer of the cleverly named Daniel Singer Law Firm is here tonight to talk about bankruptcy, give us a little intro, explain some of the nuances here and there, maybe answer some of the questions you've always had, and give us a case study sort of on a couple of different cases that have come up. And he's also going to show us a walkthrough through PACER, which if you have any experience with bankruptcy, you know that is your key tool in figuring out what's going on. So we're super excited. Thank you so much for coming to do this with us, Daniel. And if anybody cares, when you look at the screen, he's under Joel, but that's Daniel. So Daniel, you should have all of the things that you need to operate. Does it look right to you?
I hope so. I think I'm up and running. Can you see me?
I can see you. I can hear you. I can see your screen already. I think we're good.
Good. All right. Well, thank you for the introduction. I am, as Kimberly stated, the managing attorney at the Singer Law Group. We are a Southern California-based firm that primarily focuses on creditors' rights. And so what that means is we represent exclusively banks and loan servicers and majority of the note investors like yourselves in various loan workout situations, outreach, loss mitigation, and bankruptcy and foreclosure oversight. We kind of view ourselves as a complement or a subsidy to what your loan servicer is doing. They perform admin, and we sort of do all of the dirty work that they're unwilling to do or not very good at doing. So thank you very much for having me. Really excited to talk about an area that I personally have been focusing on for quite some time, which is, buying loans that are subject to either a Chapter 7 or Chapter 13 bankruptcy. And so what I'd really like to focus on tonight, first and foremost, is sort of an overview of the two chapters. And then we can kind of walk through two different loan scenarios where bankruptcy, either both at Chapter 7 and Chapter 13, are affecting the notes. And then I'm hoping towards the end of it, you'll see why I think this is a really good niche market for note buyers to sort of focus on and really separate yourself from the general masses who are just looking for, traditional non-performing first and second mortgages. So to start off with just a general overview, in our space, we primarily see
Daniel, can I just jump in real quick?
Sure.
We're going to do some Q&A at the end, and there is a raise your hand function in here. So while Daniel's talking, fish around in Zoom and figure out how to do that. We're all going to be muted while he's presenting, and then we can do our questions at the end.
Okay.
Sound good?
Sounds good.
All right, take it away.
So we primarily see two consumer chapter filings, and the two most prevalent is Chapter 13 and a Chapter 7. And there are significant differences between the two. So let's start off with a Chapter 13. And I tell clients that the best way to look at a Chapter 13 is a court mandated or a court ordered or monitored global loan modification with all of your unsecured as well as your secured creditors. And so what that means is, and what the typical scenario is you get a wage earner, as we like to call them. So you get a borrower that has traditionally fallen on hard times, either loss of job, health issues, family issues, you name it. And now they're sort of back on their feet. They've typically reached out to their credit card companies. They've reached out to the hospital bills, and they've reached out to their bank for help, either traditionally loan modification, and they haven't gotten any help. And so what they do is they go to the judge and they say, hey, Your Honor, here's what I make, here's my expenses. All of my lenders, all of my creditors, both secured and unsecured, have refused to cooperate with me. So please, Your Honor, you help me out. And that's what a Chapter 13 does. The consumer, the homeowner, or the debtor is required to make a monthly mortgage payment on their home loan. They're required to pay back over the life of a bankruptcy the past due interest to the bank. But you're kind of under the watchful eye of a court, right? On the other hand, a Chapter 7 bankruptcy generally is, Your Honor, I have no money. I'm getting calls daily from my bank. I'm getting calls daily from a credit card company, from the hospital bills that I owe, and I just have no ability to pay these people back. So I'm going to turn over all my assets to the court, and you figure out how the assets should be dispersed. Now, that's not when I say turn over, hey, I'm going to transfer title to the court, and court, you sell it. It's simply, I'm not trying to get a restructure plan here. I'm not looking for any help in getting a repayment plan. It's just a pure liquidation. If there's any assets that have equity, the court will sell it off and satisfy the creditors. We don't see much of that, and it's simply, I just want to be relieved of my personal obligations to pay it. Creditors, you do what you have to do to go after my personal assets or my secured assets, real property. And if you look at those two as the sort of the general overview of what a 13 and a 7 are, and of course there's specific legal nuances between the both with plans and, you know, payments, etc. That sort of is a good delineation of the difference between a 13 and a Chapter 7. I think sort of the best way to kind of really describe it is to actually go through a real life bankruptcy. I don't want to spend too much time going in specific plans that I've done in the past, but just sort of a general overview. One of your hosts, Wayne, was nice enough to let me use an actual case that we are working on for him. So we'll kind of, you know, go through that. Before I do, I want to introduce you to the PACER system. PACER system is a public domain site that is provided by the United States Bankruptcy Court. It links to every court in all 50 states and every jurisdiction in the states, where some states have 1, some states have 4. They all connect. For the most part, in real time, there's about a day delay in filings. You can easily sign up. You just go to PACER in Google. It's pacer.uscourts.gov. You put your credit card in, and you can have full access to the PACER. It provides you all courts, not just bankruptcy, civil, criminal, appellate. It is a great service for note buyers. It's a great service for anybody, quite frankly, in the real estate space. You can get a ton of information in PACER, and it's for virtually nothing. I believe each click is less than 3 cents. So if you don't have an account, I suggest you get one tonight. It takes 2 minutes to sign up for one, and it's really easy to use and operate. So once you sign up for an account, you'll get a username and password that's personal to you. Again, it's really user-friendly. I can type in sort of my password here. Get it to work. Oh, I lost my password. Okay, so here's the sort of the landing page that I've put us on. We're going to type in the case number that we're reviewing. And this is a Chapter 7 case. I know it's a Chapter 7 because it tells you a Chapter 7 case. It verifies the case number for you. It tells you the sort of the disposition. It tells you who the borrower is. Again, you can match this up against any data tape that you have. And it costs you nothing at this point just to get to this home page. It shows you the date of the filing and the date the case is closed. And then the date of the discharge. So again, really easy. Hasn't cost us really anything at this point to find this information. And then once you sort of click on it, it's a real sort of clicking kind of system, and everything is highlighted that you can click on. You're always going to get sort of this home landing page. And, you know, I would probably play around with the information that you can get on this page. It tells you who the attorneys are. It gives you the claim registers. It gives you a list of who the creditors are in your case. It gives you the initial notice of filing. It gives you all of the party information, who the Chapter 7 trustee is overseeing the case. And again, you can get all this information, you know, for the most part, free of charge on Pacer. I prefer to go to the history and documents page. I run my query. And again, this is what a traditional Chapter 7 bankruptcy court docket is. So this is the actual court docket. If you went down to this particular court and you asked the clerk of court for this docket, this is what she would give you, or he would give you. And it goes by date entry. And so it's in, you know, date order here. Here's the voluntary petition. And in any bankruptcy case, the bankruptcy is started by filing a voluntary petition. It's court forms. It's about 30 plus forms that you file. They're virtually identical with the exception if the Chapter 7 has some specific documents that you acquire, as does a Chapter 13. But once you sort of go through a Chapter 7, the documents for the most part will be virtually identical as to a Chapter 13. But this is the initial document that every borrower is required to file in order to start a Chapter 13 or Chapter 7 bankruptcy. And again, I would play with all of these documents. It tells you when all of the hearing dates are going to be. It tells you when all of the motions are going to be, where to go if you're interested in actually attending some of the motion you know, hearings to see what's going on. Everything is here on this Pacer account. And I always, as sort of as a practice of mine, I like to click on the petition and I like to read the petition, even if you know, it gets a little, you know, redundant in some of the stuff. And it's about $3 typically. Pacer sort of caps your charge at $3. You can never exceed the $3 limit. So again, you go on this and you read it kind of like you would any sort of due diligence package if you were to acquire this loan. It gives you the background information on the borrower. The borrower talks about where they work, talks about who they owe money to, what their monthly expenses are. It gives you the contact information for who their attorney is, the telephone number for the attorney, should you want to reach out to the attorney. You can get an email address in many cases for the attorney. Again, should you want to email the attorney. If you go on, it tells you all of the real estate the borrower owns. You know, here's our subject property. You get to see the value of the property, what they owe. So there's a ton of information that you can get. And we spent $3 on this petition, and you know, a ton of information. Here's all of their bank information. So I would strongly encourage, you know, any note buyer that is looking at bankruptcy loans to subscribe to a Pacer account, really walk through, almost go and click on every document just to really see what each and every single document means and how it applies to your relevant case. What's unique about a Chapter 7 bankruptcy that you won't see in a Chapter 13 is you'll see what's called a statement of intention. And what a statement of intention is you tell the court, hey, yeah, I have no money presently to repay the obligations, but you know, under the unlikely circumstance, or in many cases likely circumstance, that the lender does want to work with me, I would like to reaffirm that I'd like to keep that property. And so unique to a Chapter 7 is what's called the statement of intention. And here's a statement of intention. And this particular borrower has told the property, hey, told the court, yeah, I want to keep the house. I want to be responsible for the monthly mortgage payments. And look, I want to pursue a home loan modification, right? And you have really two choices in a Chapter 7. You can either retain the property, work something out with the bank to keep it, or you surrender the property, which means, hey, bank, you come, you foreclose, and you take the house, right? If in many cases, you'll get a situation where a borrower surrenders the property, you reach out to the borrower or the borrower's attorney, and it's a great deed in lieu opportunity, right? They don't want it. In many cases, they're not living there anymore. They're just looking for somebody to come and take the property from them. So that's sort of the one unique opportunity here in a Chapter 7 is this sort of statement of intention, which you do not file in a Chapter 13 bankruptcy. So if we jumped over out of this case and went into a Chapter 13 bankruptcy, again, my borrower, date they filed, and the chapter they filed. And then here's the full case number. I click on it, super easy. Same identical query system that you would see in a Chapter 7. In fact, in every case, this is an identical landing page. So you'll get into your system, whatever your sort of due diligence process of what you'd like to review. Again, I always click on the history and the documents because I like to see the court docket and what documents are there. And you'll notice, again, it is identical in a Chapter 13 it is to a 7. The landing page is going to be the same. To our no surprise, again, the case is started by a voluntary petition. Here it is. The voluntary petition is always going to be the first entry for the most part on the court docket. When we click on it, you'll notice that it should be virtually identical to a Chapter 7. And again, there it is. It's identical to a Chapter 7. So once you read enough 7s and 13s, you'll notice that they're both the same. You'll create your own due diligence sort of practice of the documents that you look at. Again, they'll be the same. So if you like to look at certain schedules, they should be the same for a Chapter 7 and 13. Again, with a Chapter 7, you'll have the uniqueness of the statement of intention. In a Chapter 13, you'll have what's unique is they have a Chapter 13 plan. And again, I look this as, hey, this is what I'm proposing to you, court, as my loan modification plan. Again, that applies to all creditors, not just my secured real estate, but it could apply to my auto lender. It could apply to my credit cards. And it's an outline of how you intend to pay everybody back. Okay? And over what period of time? In Chapter 13, we typically see 2 different payment periods. It's either 3 years or 5 years, right? The max you can do is a 5-year or 60-month plan. And the shortest period of time you can do is a 3-year plan. And again, when I say 3 years or 5 years, that's 5 years of ongoing, unmodified monthly mortgage payments. Plus, if I owe arrears of any amount, that amount is divided over the number of months that I'm going to be in bankruptcy. So in this particular case, let's say they owe $25,000 in arrears. In order to determine what the pre-petition payment will be, it's just that number divided by 60. It's as simple as that. So you total that plus the current monthly mortgage payment, and that's what you'll get is what the borrower's post-petition obligation is to you. So this Chapter 13 plan, again, this is unique to the Chapter 13, is really, if you look at it as nothing more than a repayment or a, loan modification application as to what they intend and pay it back and how they're going to pay it back, it really makes more sense versus, I get a lot of clients saying, I have no idea what the mortgage payment is going to be. Very simple. It's all in the Chapter 13 plan. For the most part, the plans are all general in nature for all jurisdiction. So, if you read one in California, it should look the same, hopefully, in Florida as it would in Nebraska and all over the country. So you're not, really trying to have 50 plus different plans that you would have to review. And what I also like, that you'll see a lot more action in a Chapter 13 than you would be in a Chapter 7. I mean, this case was only recently filed. It was filed in February of 17. The other case was filed back in 2014. And you can see the amount of paperwork that has already been processed in this case compared to a Chapter 7. So, if I'm looking to buy this loan and there is pages and pages and pages of filings, it would be a good sort of opportunity for you to really spend some time to look at it to see, hey, what is going on here? Do I have a situation where I have a disgruntled borrower that is really contesting, the lender's ability to enforce their lien obligation? You don't see that much in a Chapter 7. Chapter 7s usually last around 90 days. You're in and out. Again, as we talked about at Chapter 13, you're either in there for 3 years or 5 years. So you'll see a lot more paperwork in Chapter 13 than you would in Chapter 7. You'll see quite often some sort of opposition by a lender or the trustee to a Chapter 13 plan. Good rule of thumb is to read it, because it kind of tells you whether the consumer, the homeowner, the debtor has the ability to sort of repay your obligation, the likelihood of success in a Chapter 13. So again, I would spend some time. The cost is nominal for the most part to compare to other your due diligence costs, to really read, a good chunk of the paperwork that's filed in a Chapter 13 as well as in a 7, because it's really good information. One of the nice features on the PACER system is they have this sort of little drop or click button right here that you can kind of review what what was filed, so you don't kind of make sure it applies to your property. I say that because it's not uncommon for a borrower to have 3 or 4 different properties, and you don't really care about a property that's located on in 2 states away. All you care about is your property. So if you see motions filed relating to some unrelated property, it'll actually tell you the property address for the most part in this. And so if it doesn't relate to your property, you could just ignore it and save yourself, in this case, 10 cents for having to read the motion. You also, which is kind of a cool little, not trick, but a sort of way to scam the PACER system, is if you make an appearance in a bankruptcy case, meaning if, for example, our office were to follow a request for notice in a bankruptcy case, and you designate a specific email address for you in bankruptcy, you get a free look at every single filing in a bankruptcy in that particular case. So if this particular case, in which we will do this for our client, is we'll make an appearance and we file a notice and it says, hey, we are representing the creditor in this particular case. We'd like to receive an email of every single document that is filed in this case. Those documents are then emailed to us every time they're filed. Some relate to us, some don't. And then we get to review those documents free of charge. And quite frankly, any creditor can file those documents. And in many situations, you don't even need an attorney to file it. The United States bankruptcy courts accept paper filings. And you can go onto the United States Bankruptcy Court website. You can fill out the paperwork online. You can mail it into the court. They'll upload it for you. And sure enough, you'll start receiving emails. The downside of that is you receive a ton of emails, hundreds and hundreds of emails. I mean, I receive thousands of emails a day of every bankruptcy case that I made an appearance on. But if you're buying a single asset, whether it's in a 7 or a 13, and you're trying to minimize the cost to yourself or your JV partner, and it's just one case, hey, it's a great way to save a couple of bucks every month, and you get a free look at what's going on in the bankruptcy. Any sort of preliminary questions so far?
Excellent timing. I just got one. Question for you. If we buy the note during the BK proceeding, does that affect the
Sure.
note or the bankruptcy? I guess assuming if it's during the process and you buy into it, is that an issue?
Right. So the way it works in bankruptcy is no different the way it would work when you buy a loan that's not in bankruptcy. You get an assignment from your seller and you record the assignment with your county recorder's office. In a loan affected by a bankruptcy, we get the assignment and we file what's called a transfer of claim in a Chapter 13. And we just let the court know, hey, there's a new creditor involved. Please start directing payments to either the existing servicer or the newly appointed servicer. So it has no impact whatsoever on a bankruptcy, whether that's a 7 or a Chapter 13.
Great.
So a hand raise?
Are we allowed to talk, or?
I think we'll let it happen.
Is there a way to challenge an automatic stay if the note is already in? As often case, the bankruptcy is filed last minute and maybe missed, and sometimes it's the second or third bankruptcy. So does it automatically cancel the foreclosure, or since you can file, you have the automatic?
So there's some audio issues, but what I think I heard is if you have a situation where a foreclosure sale occurs and without the knowledge of the trustee or the lender, the consumer homeowner files bankruptcy, let's say an hour before the foreclosure, does that invalidate the foreclosure, even in situations where you have a borrower or debtor that has filed multiple bankruptcies?
Yes, that's correct. And usually they take the stance to cancel it, but in some instances I've seen people try to file motion to remove the stay.
Right.
So I wonder if that's successful in some cases.
Yeah, so having dealt with that situation many times, it's a judge by judge basis of whether they will invalidate the foreclosure sale or they'll allow the foreclosure sale to proceed. And we usually file the best practice is to always seek court permission, and you can ask the court for retroactive relief. And you explain to the court that this is a repeat filing situation. There is no likelihood of a reorganization. The foreclosure was conducted without knowledge of the bankruptcy, and you can request in every jurisdiction retroactive relief, and that relief will apply to prior to the foreclosure sale, and which would validate that foreclosure sale. Now, because the relief is so extraordinary of what you're asking a court to do, which is, hey, you have a borrower here that has lost a property or property's been foreclosed on, the circumstances have to arise as such that a judge truly believes, and this is a judge sitting in equity, that it was an abuse of the bankruptcy system, that there was clearly no intent to reorganize when they file it. And multiple filings doesn't always rise to the level of abuse of the bankruptcy system. You can have situations where a borrower, whether the sales occurred or not, that has filed many bankruptcies, and a judge still lets the case go on because let's say you have a Chapter 13 case where the borrower just misses a payment 2 years into the bankruptcy and that case is dismissed. Then they refile, and again, they go a year in that situation and then the case is dismissed. Then they refile, then they go maybe 3 years and the case is dismissed. On paper, that is an abusive filer, right? They're filing multiple times in order to avoid foreclosure. But the courts will say, no, it's not an abusive filer. It's just a struggling homeowner that lives in my jurisdiction, and I'm appointed by some government official to look out for my constituents, and so I'm not quite sure it's abuse. So to get that sort of abusive position and aspect for retroactive release has to be an extreme situation. But yes, it is possible to answer your question.
Thank you.
And that's key, and I tell clients all the time, I mean, unlike state court judges, bankruptcy court judges are judges in equity. And so they tend to be very debtor friendly. They tend to look out for the consumer. They will, in any possible way, will try to bootstrap lenders to some sort of loan modification. To allow a lender to enforce their obligations outside of a bankruptcy court is an extreme measure. Federal court judges have very large egos as well, and they would prefer to oversee everything themselves, as opposed to allowing some state court judge to, allow a foreclosure to commence. So it's something to consider when you think, hey, the borrower missed a payment, I'm going to quickly run to court and get relief from the automatic stay. It doesn't always work like that.
Can you explain what you mean by judge inequity? What's the difference between a state judge and a federal judge? Or are they not all in equity?
Well, state court judges tend to look very much to state statute and state case law in their decisions and how they rule on cases, right? Federal court judges will look to it as a guide, but at the end of the day, they try to balance out the equity, the fairness to both parties when they make decisions. Federal court judges, for the most part, are appointed for life to the federal bench. State court judges are not. State court judges tend to be very fearful of an appellate judge overruling a decision. Federal judges are not. Federal judges tend to make decisions that they think is the right way because they think that's the right rule. And they're okay if you want to take them up on appeal. State court judges tend not to go that route.
Very clear.
Anybody else have any quick questions before Daniel dives back in? Okay.
So I want to go quickly then back to a Chapter 13 case. And just to look, as many clients ask, it calls what we call as a claim register. And what a claim register is, when you are letting the court know sort of, hey, this is what my loan balance is, this is the monthly mortgage obligation, and you file what's called a proof of claim. And so when you're buying an existing loan, a loan that's subject to a bankruptcy, it is imperative that you always pull the claim register to see exactly where your obligation is, what the monthly payments are going to be. In many situations, as we know, the information that the sellers give us isn't necessarily accurate.
Very.
And so a good way to determine what the monthly post-petition payment is, where the loan stands in terms of its obligation, is to review the proof of claim. And in this particular case, the lender that we've acquired their interest has filed the proof of claim. You can click on it, and it tells you a great deal of information about the mortgage. And I always bump up the claim against what the loan service or the data tape is in terms of the loan history, the loan amount, anything. So it'll tell you, and actually you can get a copy of the full collateral is typically attached to it. Several years ago now, the bankruptcy court required you to file almost a full pay history that you have to attach to it. It's right here. This gives you a good pay history as to, from not quite as far back as origination, but pretty far back through current. It gives you the advances for taxes and insurance. Again, you can get all the collateral, all of the assignments up into the filing lender is all in there as well. So if it's missing assignments, it's a good sort of question to ask, hey, what's going on? And again, this is basically a substitute of an O&E report. And this is essentially an O&E report that they have filed minus, liens and judgments and quitclaim deeds that you get on an O&E report. So it is imperative. This document, I would say, is just as important as reviewing the voluntary petition. It is just as important as reviewing the Chapter 13 plan. And again, this is unique to a Chapter 13 case. In a Chapter 7 case, you don't really file claims for the most part because it's a real liquidation. What you owe is not necessarily as relevant unless there's a huge equity in there. but you will see it almost in every Chapter 13 case. Just get out of this, get back to the main screen. And the one nice feature both in a Chapter 7 and a Chapter 13 is you get all of the contact information from the borrower. You get the last 4 digits of their social security number. So if you don't have it for running credit purposes, you can get it right here. Again, it gives you the email address for this particular debtor. I actually reached out to this firm earlier today to see if there's the opportunity to discuss loan mod opportunities should this borrower not make payments. So you get a lot of information for loss mitigation and outreach purposes that you would not normally get if you were buying a loan that wasn't subject to a bankruptcy. That gives you the trustee's information. So if you ever need information from the trustee, a trustee ledger, etc., you can get it all right here. It gives you their email address and their phone number. So again, this page costs nothing for the most part to get, and it gives you good information as to the outreach as to how to contact the borrower and or the borrower's attorney. I'll spare any sort of real detail into the cases just for time purposes. But again, I would strongly encourage you to really spend some time reviewing the petition. I think you get a ton of free information on there, or nearly free information that you would just never get if you were buying an NPL that wasn't subject to a bankruptcy at a really great discount. Financial information, banking information, personal information around the borrower. I mean, I like to see how many kids they have. I mean, you can get a really kind of almost weird amount of information that it's all public record from the borrowers when you're doing due diligence purposes. Any other questions?
I don't see any hands up. Nobody's shouted me a question either, so keep on going.
Well, that's really, let me see if I can see here. Just to give you kind of an example of what I'm talking about. So I know when I was saying sort of due diligence here, I know that this borrower believes that their property has a fair market value of $62,000. Again, I don't know what basis they have to believe that. Borrowers tend to devalue their property, but again, I now know what the borrower believes that they believe that their house is worth. And I also know just from their bankruptcy schedules, I got a lot of debt here. Where they work. I know what they do for a living. I know how long they've been employed there. You get a ton of information regarding their income, how they've arrived at their income, their debt obligations. Now, Joel and I were talking the other day about a case that he was kind of on the fence, and I said, hey, this borrower has 3 kids, all under the age of 6, living in a house. What's the likelihood that they're going to allow the house go to foreclosure? And all of that's listed here. So if your play is a loan modification play, this is key information that you would want to consider whether you think that the borrower is going to want to retain this property. How easy is it to displace, a homeowner that has 3 kids all under the age of 7, right? Conversely, this consumer has no dependents whatsoever, living on Social Security. Maybe it's a little easier for them just to pick up and walk away. I don't know, but it's information that you would never get from an O&E report. You wouldn't get it from a BPO. I mean, you certainly wouldn't know what their monthly obligations are, what their surplus income is going to be, whether they have the ability to repay the obligation. Again, all of it is required to be disclosed in a bankruptcy schedule. This is just sort of brief amount of information that you get while I'm, buying loans. And This is kind of one of the reasons why I like to buy loans in bankruptcy versus, loans that are not, because I get a ton of information about the consumer, because at the end of the day, that's what I'm underwriting. I'm underwriting the value of the asset and the individual that's residing in there, that I would normally get from any other due diligence documents on an asset I buy. And again, this would be in the Chapter 7 case as well. They're required to file the same documents, the same schedule, so you get the same information on a Chapter 7 as you would in a Chapter 13. You'll even get employment here. Look, they filed their employment records. You get a lot of times in many places they're required to file a BPO or an appraisal. So all of information right online, less than $3 to get it all. We would not normally get it unless you're buying loans in bankruptcy. Any questions?
Yes, we have a couple. Let's see. Jim asked, in a Chapter 13, if there's only partial equity in your first or second lien position, can the court require a modification so that your amortization schedule payments are reduced to conform to an equity position?
No, the court cannot create equity in a bankruptcy. And the court, for the most part, cannot force a lender into a loan modification situation. Several states, Florida, others, have what's called a bankruptcy mediation program that the debtor can opt into. And if they opt into it, the lender is forced to attend the mediation and discuss loan modification opportunities. If a lender insists that a modification is not possible, the court certainly would not require it, nor can they cram down or modify the interest rate, or for that matter, the outstanding balance to create equity. Now, in a 13, you can strip off a wholly unsecured second, with meaning if you have a house that has a fair market value of $100,000, you have an outstanding balance owed to the first of $200,000, so your negative equity, you can completely strip off that second lien in a Chapter 13.
Oh, go ahead. Sorry. Can
And
a
that's
lien
unique to a
ever be-
Chapter.
Sorry.
Go ahead.
I was just gonna say, can a lien ever be partially stripped? It's either stripped or not stripped, right?
It can be partially stripped if it's investment property in a Chapter 13.
Okay.
So non-owner occupied property can't be partially stripped. If you have $1 in equity in a second, then you're fully secured. In an investment property, it can be crammed down to the fair market value of the property. But the court cannot modify the interest rate.
Okay. You ready for another question?
Sure.
Tim asked, is a BK 7 or 13 better for a note investor, or does it just depend on the details of the case?
There's a benefit to the 13 in that, hey, if you as the debtor, if you want to be successful, you have to make monthly mortgage payments. So if I want a cash flowing asset, then I'm going to ideally look to a Chapter 13, because that is the obligation of the debtor in a 13, is to make mortgage payments. On the other hand, a Chapter 7, by getting a Chapter 7 discharge, that homeowner is no longer responsible for the $100,000+ in credit card obligations that they've incurred. So really the only main creditor they have to pay is probably me plus their auto lender. So, whatever cash they do have, be allocated from these folks versus somebody else. But again, it's a case-by-case situation. You'll get many 13s where you look at the plan, you look at the schedules, and you'll say, hey, look, there is no likelihood here that this borrower is going to be successful. And then quite frankly, they should have probably filed a Chapter 7. And in some cases they will. They'll convert from a 13 to a 7. On the other hand, you'll see Chapter 7 cases where you look at it and you say, man, this borrower, if somebody would have just reached out to offer some help, they probably could, keep the house and start making mortgage payments. According to their statement of intention, there's the desire to stay. And so that could be a great opportunity. Case by case for the most part. Again, keeping in mind that in a 13 they have to pay, and a 7 they don't.
Okay. Let's see. Next one. Do you invest in Chapter 7s? Why or why not?
I'll invest in really any chapter in any bankruptcy. I'll buy 12s. Not, I don't do many 9s because I don't do public debt obligations, but 11s, 13s. I'm not scared off by the chapter they file. Again, I like it because I like the underwriting borrowers as opposed to properties. And I think if in a Chapter 7 case you get a situation where the debtor is has family members that are dependent upon them, specifically young children, and they're wage earners, so you can see they have some income and it's positive income. I'll invest in the loan, whether it's a 7 or a 13. On the other hand, on a 13, if I really want the loan to perform, again, I look at it and it's a wage earner and I think they can perform, I'll invest in the 13. To me, it doesn't matter.
Okay. Next question. It appears there are advantages to Chapter 13 notes, but what are the potential risks of a BK7?
So in a BK7, at the completion of the BK, both in a 13 and a 7 for the most part, you get what's called a discharge. In a 7, the discharge says, hey, I have no personal obligation to repay the loan. Meaning you can't sue me personally for any deficiency judgment. You can't come after me on a breach of contract claim for my credit card that I didn't pay. So it makes outreach from a loss mitigation standpoint difficult because you really can't reach out to the borrower and to discuss home loan modification opportunities. You almost have to wait for the borrower to reach out to you. Now, if the borrower reaffirms the debt, or in many cases, they filed 5 years ago and they've been making some payments throughout the last 5 years, we'll as a firm send out a letter to them to invite them to contact us. But it's a very soft, non-threatening letter. So the downfall is just the outreach efforts. You got to just model in that I'm going to have to foreclose. And then the foreclosure hopefully triggers them or prompts them to contact you.
Okay, let's see. Scroll. Ian asked, if a borrower has equity, what are the advantages to filing BK rather than agreeing to a forbearance plan if the borrower wants to stay?
You got to remember, though, is that in a bankruptcy 13, for example, many borrowers, the lenders are just unwilling to work with them. So the predecessor to you may say, I'm not willing to, I don't offer loan modifications of any kind. And the borrower wants to keep their house. And the lender's starting foreclosure. So the borrower doesn't really have many options other than to sell the house, right, to satisfy the debt obligation, or file bankruptcy. Because we'll get situations all the time where, B of A reaches out to the borrower and said, hey, we like a one-time payment of $50,000 in order to consider you for modification. How many of the borrowers do we know that have that kind of cash sitting around? So under a Chapter 13, as we discussed, their only 2 requirements are to make on-time regular monthly mortgage payments, plus pay back the arrears over either 5 years or 30 years. And the lenders have to accept it. So it's kind of a way to force a lender into I don't want to say a modification, but to accept payments where they wouldn't necessarily have to if they weren't in bankruptcy.
Okay. Let's see.
Equity in a house in a Chapter 13 is not as of an issue as in a 7. In a 7, if there's equity, the court would typically the trustee will sell the asset to satisfy the creditors, and they take the proceeds from the sale over and above what's paid to the creditors to satisfy the unsecured creditor. So equity is really only an issue in a Chapter 7. But if you own in equity with a Chapter 7 and the trustee is going to sell the asset for you and pay you off in full, who's complaining about that?
Yeah,
and the trustee hires a broker, the trustee markets the property, they handle all the paperwork at their cost. Great, delighted, please sell the house for me.
All right, let's see, next one. When does the borrower pay the trustee versus the servicer of the loan?
So it's by jurisdiction. Some states or some districts say if you were if you are delinquent on your mortgage payment when you file bankruptcy, all payments, so pre-petition payments as well as post-petition payments, have to be administered as a conduit of the trustee. Some give the borrower the opportunity to make the decision whether they want to pay directly to the lender or they want to pay through this to the bankruptcy trustee. The pre-petition payment, so the amount that the borrower owed at the time of filing, I call it the pre-petition amount, those always go through the Chapter 7 or the Chapter 13 trustee. It's only the mortgage payment, so payments from filing going forward, that go either route. And if you go through the Chapter 13 trustee, you pay 10% premium to the court. So you pay 10% of whatever that monthly payment is, you have to pay on top of that to the trustee. Not you, the debtor does. So that's why the debtors try to pay outside directly to the servicer.
Okay.
We get questions all the time from clients and saying, hey, can we call the borrower and tell them to pay us directly? And I always say it doesn't work like that. And it's very jurisdictional. So some jurisdictions don't allow that. So if that's the election of the borrower, you kind of just have to live with it. And the first payment in bankruptcy is due 30 days after the filing of the bankruptcy.
Okay. Making my own notes here. Okay. Next one. If the creditor does not want to negotiate any modification and wants to go ahead with the foreclosure process, what is the typical time frame to be able to sell the secured asset outside of the bankruptcy court through foreclosure?
Okay, so if I were to file bankruptcy today, August 9th, my first post-petition payment would be due September 1. Let's say I missed that payment. So come September 15th, let's call it, I can petition the court for a motion for relief from stay. And I could say, hey, Your Honor, I'm not receiving post-petition mortgage payments and I'm entitled to relief from stay. That is one element of a bankruptcy, is that you have to make payments. Let's say the court gives me that relief. That notice period is 21 days for most districts. So 21 days. So you're looking at a mid-October hearing date. I usually can get an order back from the bankruptcy court within 5 days, and then 5 days, and then you can start your foreclosure process thereafter. So if I miss September 15th, you'd probably be looking, the first time you can start foreclosure would be the first week in November. Maybe mid-November.
All right, let's see. Next one. This one's from Wayne. Does the trustee always sell the house in a Chapter 7?
If there's equity in the case, so there's equity over and above what's owed, they add 10% real estate commissions and costs to it. If there's equity, now equity is not a dollar. You know, if you're looking at $30,000, $40,000, yes, they will typically sell the asset. If it's $5,000, it's not worth the time of the trustee to try to sell it.
Okay.
Now, some states have homestead. I mean, there's exemptions that you get as a debtor. That's what I'm saying. The equity has to be something more than just a couple bucks.
Okay. Next one. How many times can a borrower file BK back-to-back just to stall foreclosure?
Case-by-case basis, court-by-court basis. It all depends on what the reasons were for the dismissal of the bankruptcy and the refiling. If it's just a pattern of practice of filing, they get dismissed 30 days later, then they refile and they get dismissed. Usually by the second dismissal, we're usually asking the court for in-rem relief. So that's relief against not only the present case, but all future filings as well.
Okay.
But again, if I file my bankruptcy today and then it gets dismissed 30 days, it all depends on the circumstance of the dismissal, right? Hey, my attorney forgot to file paperwork. That is quite common, is what happens. I mean, that is in many situations. I didn't show up to my meeting of creditors because I was sick or my kids were sick, and so I refiled. Does that constitute an abuse of the bankruptcy court? Probably not, even if there was a foreclosure when they filed. Clients say all the time to me, well, they filed the day before a foreclosure, an hour before the foreclosure. It's bad faith. And I said, no, they filed because of the foreclosure, and that's not bad faith. That's why people file bankruptcy, is because they're trying to prevent the sale of their home to reorganize. So simply because of the timing of a bankruptcy filing to when the foreclosure doesn't in and of itself amount to a bad faith filing or give you grounds for relief from stay.
Okay. How often do borrowers fail after completing BK 13 if they've already gone 3 or 5 years?
I would, and the estimates used to be around 80% of borrowers defaulted on the plan at one time during the bankruptcy. I would assume it is probably still around that time. It is very uncommon in my experience to see a borrower survive 5 years of payments. If you just look at it from a practical standpoint, a homeowner who hasn't paid in 5 years or 6 years, how are they going to pay the full monthly mortgage payment plus all the arrears back? It is, I mean, they weren't able just to pay the monthly mortgage payment. Now you add on an extra 200, 400, whatever the number is, plus 10% to the Chapter 13 trustee. It is very difficult for them to survive in bankruptcy.
Okay. Barb asked, I buy seconds. I have a borrower with BK7 discharged in 2009. I
Okay.
foreclosed. There's no equity. The redemption period has passed. It's Michigan. Borrower is not interested in talking at all. Do I have any remedies?
So you have foreclosed already and you're now the owner of the property.
That's what it says.
Your remedy is to evict them.
Okay. Let's see. I'll let you know.
The other option is what, a cash for keys for them to voluntarily vacate.
Okay. I'll let you know if Barb asks any follow-up questions at the end. All right. Next one. How many times can someone file BK?
It's unlimited. It's unlimited until the bankruptcy court tells you can't file anymore. And even then, it's about 180 days will they prevent you from refiling. So I've seen borrowers with 10 bankruptcies. I've seen plus 10. So, it all again is on the circumstances surrounding the bankruptcy.
Okay, let's see. On average, how many, oh, wait, you just answered that one. So if you said 80% don't pass, that's 20%.
It's really high about how many fail in bankruptcy, yep.
Right. I hear that most often the borrower does not comply with the payment plan and the case is dismissed. When a
Correct.
discharge does occur in a 13, what is the consequence to the note holder who is still owed amortization payments after the plan term ends?
Okay, so let's say in this particular case, this borrower that filed on this in February goes 5 years, right? At the conclusion of 5 years, this borrower in theory should be current. So all the arrears should be paid current, and the borrower should be next due for, February of what, 20, whatever that is.
Mm-hmm.
So at the conclusion, they'll be contractually current. That's the consequence. Now, if I were then to buy this loan in 2030, let's say, and they hadn't made payments since discharge through current, there's no consequence of the bankruptcy. They're in default, and you would just start your foreclosure.
Okay. Next, for a Chapter 7, is there a point where you can request that the mortgage be removed from their BK so you can try to work out a modification?
Yes, if you, at any point in a Chapter 7, you can seek relief from the automatic stay in order to enforce your state court remedies and or engage the borrower in a loan modification discussion.
If you manage to remove the stay and foreclose on the homeowner, but the homeowner has not left the house and is now a tenant at sufferance, does his tenancy get any protection from the bankruptcy?
No. Once you get relief from the stay applies for the foreclosure as well as all subsequent eviction actions. Now, they can file bankruptcy to stop you from evicting them. And again, you'd have to go through the same process. But if that doesn't occur, you would be able to evict them as well.
Okay. And this is the last one I have on this screen, but I have some written down. If I already have a judgment and the sale date is set, then the borrower files BK before the sale, what happens?
So traditionally in a judicial state, what you do is you file a notice with the state court that there's a bankruptcy affecting the state court action. It would stay any enforcement action in the bankruptcy. And then you would then, you'd have to deal with the bankruptcy court. Again, the borrower makes those payments for 3 or 5 years. You receive those payments, and at the conclusion, your state court foreclosure would be mooted.
Jim asked, is Chapter 11 BK available for individuals?
Yes, Chapter 11 applies. It's based on the amount of your debt obligations. So if you have a secured obligation of $1.01 million or an unsecured obligation of $364,000, they may have raised the limits a little bit, then you're automatically forced into a Chapter 11. Now, if you're buying heavy West Coast properties, so Southern California, it is not uncommon to see an individual who has a house in Newport Beach in a Chapter 11 because the debt obligation could be $3 million. So you won't see it a lot in the Midwest and some of the southern states where they have one property. The property maybe is worth $50,000 or $60,000, but you will see it a lot on the California, maybe some in South Florida, maybe some if you're buying heavy in the city of New York. So that's where you really see a lot of Chapter 11s.
So do borrowers generally file Chapter 11, or do they start in a 13 and then when you look at the numbers, they're converted to an 11?
Yeah, so if they'll file a Chapter 13 not knowing the limits, and then the court forces them to convert it to a Chapter 11.
Okay. Next one. I have purchased a second lien where the borrower previously went through Chapter 13.
Okay.
The second lien at that time was underwater, and borrower thought that the second lien was stripped and he didn't have to make any payments on it. Is the
Okay.
lien stripping automatic or subject to any other conditions?
In order to strip a lien in a Chapter 13, you have to file the necessary paperwork to get it stripped to the bankruptcy court. So simply telling the court, I intend to strip it and nothing more, isn't sufficient. You either have to do it in your Chapter 13 plan, you have to bring an adversary proceeding or a complaint, or you have to file a motion. If that wasn't done, it's still a valid lien on title.
Okay.
And you'll get that in Chapter 7 as well. Oh, I'm not obligated to pay that anymore because the asset was underwater, so it's stripped. No.
But after a loan is, even if it is stripped, isn't
Yes.
it now just unsecured debt?
During the bankruptcy, it's treated as unsecured, and post-bankruptcy discharge, technically, I guess it's an unsecured, but it's an unsecured, unenforceable obligation.
Okay. Because it's no longer secured and they're no longer responsible for it. So,
That's correct.
okay. Let's see. Ian asked, how long from initial filing to first payment being due? You said 30 days, right?
The rule of thumb is 30. Now, again, in my situation, if I file today, my first payment would be due September 1.
Okay. But doesn't the judge have to approve the plan first?
No, the obligation to make post-petition payments begins day one. The filing of the Chapter 13 plan doesn't dictate when payments are due.
Okay.
Several jurisdictions, the trustee will hold the post-petition payments until the plan is confirmed. So if we take this case right here, let's say this borrower started making payments, March 1, they made March, they made April, but the trustee was holding payments until May on confirmation. At the end of May, because the trustees for the most part write checks at the end of the month, you should get payments for March, April, and then May. You get 3 post-petition payments.
Okay. So the plan has to be approved before the post-petition payments are distributed. What about the pre-petition payments?
If the trustee is acting as the conduit, then that's correct. If the debtor is paying outside the plan, then they are required to pay you directly, and this borrower would be required to pay in March, April, May to the servicer directly. The pre-confirmation payments, in this case, we said it was 20-some thousand divided by 60. Those won't be starting to be dispersed until confirmation of the plan, because those always go through the Chapter 13 trustee. They're never paid for the most part directly to the servicer.
Okay. Let's see.
So what would happen? I mean, look at this could be a great financial opportunity for a downstream buyer when you get, for example, somebody that buys and then flips the loan out. Maybe they bought the loan, you bought it, you know, here, you bought it in April, and in your PSA, you said, hey, look, I get all funds that are dispersed post-purchase date. Well, if the funds don't get dispersed till May, who gets all those monies?
Okay.
So anytime I buy a loan in bankruptcy, I tell the seller, hey, look, I get any funds that are dispersed, not necessarily earned, but dispersed after closing date. Because I know in many cases, they're sitting at the Chapter 13 trustee waiting to be dispersed.
That is an incredibly important nugget. Okay.
And here you'll get a situation where the seller says, oh, it's non-performing in bankruptcy. Well, why is it non-performing? Because I'm not receiving payments. Oh, okay. So then I price it as an NPL, non-performing. Okay. Again, the borrower, I look at the plan, payments are going to the trustee. I can email the trustee and ask them, are you receiving payments every month? Can I get a copy of what the pay history is? Okay, I got an NPL price.
Okay. All right, next one. In Chapter 11, the court can do cram downs, correct?
That's correct.
Okay. If around 80% do not complete the bankruptcy, what percent of that 80% have you found are successfully foreclosed upon?
Well, eventually you'll get foreclosed upon. So I would say 100% of borrowers in general, if they don't make their mortgage payment, will lose a house in foreclosure. Unless they sell it or they pay me off. It may take years to get it, but eventually I'll get it.
Okay.
You think if a borrower say 3 years in a bankruptcy and they default, you as the note holder would reach out to them and say, look, you've been a great borrower, you've paid every month, I understand you had a life circumstance. Maybe that's a good opportunity to offer a loan modification.
Okay. Regarding holding the payments until the plan is confirmed, does that apply to the whim of the judge on the case, or is that depending on what BK court is handling it?
It's depending on the court that's administering it or the trustee that's administering it.
Okay. Follow up on eviction after foreclosure after removing BK stay and serial BK filings. You mentioned that if the borrower filed another BK, he would get some protection. Shouldn't a creditor attorney ask for a systematic interdiction to file another BK within X months?
So I think what you're asking for is what we call it is in-rem relief. So it's relief against not only the current filing, but as well as all future filings. And as I've sort of said many times, it's not necessarily based on the number of filings. It's the circumstances surrounding the filing as well as the dismissal of those cases. So again, simply because I filed bankruptcy and I fell out and I refiled, that doesn't justify offering in-rem relief to a creditor. And in fact, in several districts now, seeking in-rem relief where not appropriate is a sanctionable offense on an attorney.
Say that again?
It was prevalent years ago where anytime there was a multiple filing situation, so a debtor would file, they would fall out of bankruptcy for whatever reason, they'd refile again, and attorneys would just run to court and say, I want in-rem relief against all future filings. And courts were just getting inundated with these in-rem reliefs. And so now what many judges do is if there's not substantial justification for it, they'll order sanctions against either the creditor or the attorney for seeking improper relief.
Joel, can I follow up on this?
Sure.
Because I've seen in practice people will manage to postpone a years by doing exactly that, filing a bankruptcy right after the other one, or this. So in practice, do they have just oftentimes it's big banks, and I'm thinking slow and they're not on the dot, but in practice as an attorney, if a person like that who just wants to file bankruptcy as many times as possible, what remedy do you have? Shorter or to limit?
Well, again, I buy BK 13 loans all the time. So in practice, I look at a borrower, for example, and I say, well, they filed bankruptcy. Let's just use this borrower, for example. Okay. Let's say this borrower files February 6th, and they never file a single document, right? They filed, in this case, they filed a voluntary petition, which we know is going to be north of 30 some odd pages. It's 16 pages, right? So we call those a bare bones bankruptcy petition. And then let's say they never file a single document, and then technically 15 days later, the court should dismiss them from bankruptcy. So let's say they dismiss them from bankruptcy, right? They dismiss them in March. And then they wait 2 days and then they refile again. That would probably be arguably a situation where I would go to the court in the second filing and say, hey, they filed the first time. They had no intention of actually meeting their obligations as a debtor, i.e. filing a full bankruptcy petition. And this is really nothing more than a scam or an attempt by the debtor to avoid foreclosure. And I've had this very same situation. In fact, 2 weeks ago, I was in court here in Southern California alone that I own in that situation. And the borrower stood up and said, Your Honor, I'm filing by myself, meaning I don't have an attorney. And I had no idea what I was doing, and I just filed the bankruptcy. But now, Your Honor, I'm going to get an attorney. I'm going to refile again. And the judge denied my motion. Right? So that's why I have to say you have to look at really what was the intent of the borrower, what are the complete set of circumstances surrounding not only the filing, but the basis for the dismissal. If I go back to the same situation, they had an attorney that filed in February. It was dismissed. They filed again. That case was dismissed 15 days later. Absolutely, that's probably a great grounds to seek in rem or extraordinary relief from all future filings. But let's say this borrower goes 6 months of making payments and then falls ill, and then the case is dismissed. Let's say they file again, they go 8 months. They lose their job, the case is dismissed. Then they get another job back, and then they file again. Is that bad faith?
Yeah. There's not one answer, very long.
Right.
Describing. Are they more?
The biggest scam that you see. Oh, I'm sorry. Go ahead.
No, Texas. So it's not as powerful as California. So did you see a difference in the way judges treat bankrupt?
Well, I mean, in Southern California, San Diego, from Orange County south is a very creditor-friendly state, a creditor-friendly district. Northern California is very debtor-friendly. So you may get parts of Texas that are very debtor-friendly, and you may get the eastern or the northern district or whatever that's very creditor-friendly. So it all depends on the district. You can go on to the bankruptcy court website, and you can see what president nominated a judge. If it was Reagan, if it was Bush, if it was Clinton, it kind of gives you a little disposition as to, how the judge is going to handle certain situations, because it says it right on there. The most common circumstances with abuse is when you see transfers of title. So Miss Kirk transfers title to some fictitious scam company or an individual right before the foreclosure, and that individual files bankruptcy. Those are sort of the most common scam situations that we see that you can get interim relief.
All right. Next question. You said that you buy notes in Chapter 13 all the time. Do you research recent BK13 filings in your area for note buying opportunities?
You know what? I have not, but I will say that I've encountered note buyers sitting in bankruptcy courts talking to lenders about note buying opportunities.
Interesting. Talking to Lynn, okay.
Because the lenders always send an attorney, and attorneys for the most part have direct lines to somebody at the bank. And so, you can get into situations where you'll get a small community bank that just doesn't want to deal with a really sticky bankruptcy, especially commercial stuff, but some residential stuff where I see guys go up to the attorney and say, hey, if your client wants us to be out of it, please have them give me a call. So it's certainly, and anybody's welcome to the court. You just need a valid driver's license.
All right. Let's see, next one. Is the cost prohibitive for a borrower to hire a BK attorney? How can they afford one when they're already so far behind on all of their other payments?
Well, they can afford it because they haven't made their monthly mortgage payment. So, the bankruptcy now, because attorneys are a dime a dozen that handle bankruptcy, you'll see bankruptcy attorneys for as cheap as $99 for a Chapter 7. Most states, most courts cap what you can on a 13, but like any business, it's a business for lawyers, and so if they can make a couple $100 doing it, they'll do it. The filing fee is nominal. I think it's like $195. It's
on a credit card?
Well, you can put it all on a credit card. You just can't, unfortunately, bankrupt it out.
All right, let's see. Do you see very many BKs that include multifamily properties?
We see BKs that have strip malls. We see duplexes. I mean, you see them for every asset class. No asset class is immune from a bankruptcy.
Okay.
I mean, if you're heavy investing in Wisconsin and Minnesota, parts of California and others, you'll see a lot of farmers. Louisiana, you may see fishermen. So, you'll see all different asset classes.
Okay. Danny asked, where do we find properties for sale that are in BK? I'm not sure.
You can actually go to a 341 meeting of creditors in your court district, and you talk to the bankruptcy trustee, the Chapter 7 trustee, and they'll sell assets all the time, and they will definitely sell to note investors. And they'd be happy to sell to you if they, as long as because they get paid, they get a commission, and they're businessmen for the most part. Most of them are practicing attorneys or accountants or real estate agents. They get paid like $40 a case, so they're not making much. And you get buddy with them. Great way to find assets.
Okay.
And they sell full level assets. They'll take over from a bankrupt bank and they'll sell thousands of them for it. So it's not just consumers, they'll do institutions as well.
All right.
I actually never thought about that, but I'm probably going to go buddy with my trustee now and see if I can get some assets that way. Good.
You may be the only speaker I know that got a nugget from his own presentation.
Nugget from a question, so thank you.
All right, let's see what's next. Where we find? Okay. Do certain liens get priority in BK, like taxes and trustee fees, or does each loan get paid with each BK payment?
So administrative fees, which typically is the debtor's attorney, for example, they take priority. They get paid first. There are certain other liens that take priority. IRS liens don't take priority. They just don't get discharged, as do spousal support and child support and student loans. But the administrative fees, the trustees' fees, they take priority as well.
Okay. Let's see. If you can ask for a loan modification in a Chapter 7, why shouldn't the borrower just be doing a Chapter 13?
I mean, if I have thousands and thousands of unsecured credit card debt, hospital bills, many of them just they wouldn't be able to pay it back. So they get a discharge. It's a fresh start for them, but they want to keep the house. So they'll, under 13, you have to pay some percentage of that back. It may be a small percent. You're also there for 3 or 5 years, and you're paying a premium to the trustee to oversee your case. So the cost to a debtor in a 13 could be quite substantial versus a 7.
Okay. Let's see. Okay, if a borrower files a Chapter 7 and indicates in their statement of intention that they want to sell the house or be released from the house,
Yes.
why do some of the cases finish, but they still haven't sold the house? Is it because there wasn't enough equity for the trustee to bother?
Right. That's exactly right.
Okay. So how does that get resolved ultimately?
So what will happen is they'll surrender the house. They'll say, come and get it, whoever wants to get it. They'll get a discharge, and then you'll start your foreclosure right away.
But you still have to do the foreclosure even though they wanted to surrender it.
That's correct.
Okay.
Now, maybe your first step is reach out to their attorney and see if they want to just do a deed in lieu of foreclosure with some cash for keys to get out. So that's always probably an opportunity that you'd probably want to do first and foremost. If that's not successful, then you just start foreclosure.
Okay.
Many of the surrenders is because the borrower's vacated the property already. So you got to look at the property plus where the borrower is saying they currently reside.
Okay. All right. So you say licensed for an attorney, or you're in California?
I am.
Is it licensed? Is that the word I want?
Yes, I am
Okay.
licensed with this law in California and Nevada.
So how can listeners work with you if they have BKs in other states, or how does that all work?
So I'm a registered claims filer in all jurisdictions. I've taken the test for the most part in all states to file certain filings. So proof of claims, transfer of claims, notice of payment changes. I can make appearances, special appearances for clients. If you needed some motion work, we have a network of bankruptcy attorneys nationwide that we will oversee that process. So, for example, this case, I think this is, what's jurisdiction this is? Let's say it's Tennessee. I have an attorney in Tennessee. I will refer a motion for relief out to them. I get all the paperwork prepared for them. I make sure that they show up to the hearing. I make sure that the hearing goes as we hope it goes. They report back to me the results of the hearing, and then I would convey it to you, the client.
Now, does that end up costing us more money?
No, it's a pass-through cost. So if this particular firm charges $550 for the motion, you pay $550.
So how do you get paid for doing your part of the work?
The firm charges a monthly management fee. It's anywhere from $50 to $75 a month for overseeing loss mitigation, the foreclosure, and the bankruptcy process.
All right. And how do you want people to contact you if they need your help?
You're welcome to email me. It's daniel@dsingerlawgroup.com, or feel free to contact me at 949-449-1574.
Okay. And we will make sure to include that contact information on the intro page to the webinar so that people won't have to listen all the way to the end again to get your contact information.
Thank you.
Does anybody else have any other questions? Anyone? Oh, Wayne said, awesome job, Daniel. I always learn so much from you.
Thank you. And I really appreciate the opportunity to talk to your group. And if anybody has any other questions, feel free to email me. I try to email and respond pretty promptly.
Great. Thank you so much, Daniel. You're getting lots of kudos here as we go along. So we appreciate it.
Thank you so much.
All right. Take care. Thanks everybody for tuning in, and have a great rest of your Wednesday.